adjust your audio accordingly.
Okay, everyone. I'm going to reconvene our biannual retreat, and thank you all again for joining us today. I also want to thank our vice chancellors who've all now just joined us to be a part of the discussion. As you've seen with the agenda, I think our goal for the afternoon is really to facilitate discussion amongst this body as well as the chancellor and the vice chancellors about the processes by which we conduct business, and then have some discussions about the things that are priority to this board and do some goal setting. But we're going to start with a presentation from Fram and Andy about the Bagley-Keene Act and how we actually then conduct business in the environment we work in as a good tutorial and a reminder. And then what I'd like to do is we transition over into the board communications, responsibilities between committee chairs, vice chairs, board members, et cetera. I'd ask Tom to feel free to weigh in where he feels appropriate and has some insights and best practices that he's seen through his experience at AGB and throughout the many systems he's been in. So with that, Fran, floor is yours.
Yeah, that 57 PowerPoint that you spent months preparing, it's eloquently and finely tuned. Is not going to be up.
Just go ahead with that.
I'll remind everyone in front of you when you're speaking to push the button in front of you, and when it's flashing green, you're live.
General Counsel, and Garrett Ashley, Government Relations, Lori Lamb, Human Resources, Steve Relier, CFO, and Smith, our provost, if you will, and standing in for Larry. Janice. I had units in my head, and I was going in a units room. Janice, our university audit.
Okay.
Floor is yours.
Well, we probably can start by saying the attorney-client privilege, then there's not a great deal that we need to say. But we do have set aside some time to talk about this. So what the plan or idea is to level set everybody on what the requirements are of Bagley-Keene, because they are a little bit counterintuitive sometimes with respect to board communications. And I know you just spent your last session having some discussions about board interaction and board communications. And so I get to be the person that mucks that up a little bit and gives you some guidelines or rules that may not fit generally with how boards of private institutions work. Let's first start with the concept.
Or publics in other states.
Or publics in other states, for that matter, as well. Let's just start generally with the concept of what the Bagley-Keene Act requires. And I'm just going to read you real quickly, because it's not up on the screen, the introductory language of the Bagley-Keene Act, where it says, the people of the state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give up their public servants to the public servants the right to decide what is good for the people, to know what is good for them to know or not know. The people insist on remaining informed so they can retain control over the instruments they've created. Kind of heavy language to start out a statute with, but the whole concept of the idea is that this is a blue sky statute. That if you keep in mind the rule of thumb that the public's business is to be done in public, and that the public has input into the public's business at every stage of that process, and that the discussions by the board need to be transparent and open to the public so they can see the information upon which you base those discussions, the deliberative process that you go through in trying to reach those discussions, and then are privy to the actual decision itself, then you pretty much will understand the Bagley-Keene Act, the purposes behind it. So what I want to do is help you set some rules for the road and answer any questions that you might have, but also encourage you that if you have questions about Bagley-Keene during the course of board meetings or before board meetings or after, you can always ask me and you can always ask Andy. I suggest strongly that you ask that offline, not during board meetings, because quite frankly, it's not a good idea to get legal advice from your legal counsel in public session. Not because there's anything to hide. I give you the same advice in open session as I would in closed, but we want to maintain the privilege to the extent we need to and can. Oh, isn't that lovely? Perfect. So the Bagley-Keene Act is in the California Government Code, and there's also separate statutes for our auxiliaries and for our student body, which mirror the Bagley-Keene Act. And you may be familiar with local and municipal governments that follow the Brown Act. All of these statutes are very similar, and if you've had exposure to the Brown Act in other areas, then you have a leg up. The first question, of course, is who does the Bagley-Keene Act apply to, or what does the Bagley-Keene Act apply to? Clearly, it applies to the board. So the board meetings, the entirety of the board. It also applies to all the board's standing committees. And then it applies to certain advisory committees and work groups, and that's really the harder part or the trickier part. Your advisory committee and working groups are covered by the Bagley-Keene Act if 3 or more persons are on that committee and it's created by board action. And remember, those 3 or more persons don't have to be trustees. They can be anyone. Anyone that the board appoints to a committee, if there's 3 or more, will create a Bagley-Keene covered committee. So if the board authorizes or directs someone, another board member or the chancellor or anybody else, to create this committee and it has 3 or more people, then it's covered by the Bagley-Keene Act. If the chancellor, acting without board directive, if the chancellor is looking for an advisory committee, a budget committee to help him in coming up with budget ideas or academic issues, that's not covered by the Bagley-Keene Act. And similarly, if there are only 2 persons on the committee, that's not covered by the Bagley-Keene Act, even if the board created that committee. So that's who's covered. And let's look at the purposes of the Act. That introductory language that I referred to really helps with that process. But the purposes of the Bagley-Keene Act are for the public to see the information gathering process, and that's really important, the information and how it's gathered and upon what you're making your decisions, the consensus building process, the deliberative process, and the process in making decisions. And it gives the public an opportunity not only to observe that, but to have input in it. That's why we have public comment before each standing committee and also before the board makes decisions. And quite frankly, we have to recognize that we sacrifice some level of not only efficiency, but also comfort in complying with these provisions. And that's designed by necessity by the legislature to make sure that we have the transparency in the board's business that the legislature has decided the public have a right to. There's some key ways in which the Act accomplishes these purposes, and there really are 2. The first is requiring public notice of meetings and putting information on the agenda so the public has knowledge not only of when you will be meeting, but also what you will be talking about, and then limiting the time in which a covered board or a committee can meet in closed session. So let's talk first quickly about notice and agendas. The public needs to know when you're going to be meeting, and the public needs adequate notice of what you're going to be meeting about so they can decide whether they want to show up, whether they want to be there and listen and provide input to you. The notice requirements are satisfied by giving notice to anyone who's asked for notice, first of all. So there's a long list of people, public institutions, the press, et cetera, who've asked for notice, and we send notice to them, and then posting it on the internet. That's a little bit different than the Brown Act. If you're used to the Brown Act where you actually had to post a physical notice outside a door for everybody to see. The The Bagley-Keene Act's been amended, so we don't have to do that like we still have to do under the Brown Act. You have to give these notices at least 10 days before your regular board meeting, and there has to be a brief description of what you're going to be talking about. That rule of thumb, about 20 words or less, and you just have to simply generally provide information about what's going to be discussed. That applies whether you're talking about an open session item or a closed session item. So you still have to discuss with sufficient information what's discussed about in closed session as well. And then an important thing to know is writings that are distributed to the board ahead of time. Information that's provided to the board ahead of time also has to be shared with the public. It has to be shared with the public if in response to a California Public Records Act request. But if you provide information to the board ahead of time, you also have to provide that information to folks that have asked for it on an ongoing basis. Usually the same people that ask to receive notice get the same information that the board gets. The exception to that are, when we'll get to the closed session items, some personnel items, attorney-client privileged information about litigation, etc. If it's protected under the closed session privilege, it's also protected from being disclosed in response to this piece. But otherwise, the public gets to see what you see. So they see the basis upon which you're making your judgments and gathering information. So if someone brings something to the board, for example, and shares it with you as board members, then the board, that has to be made available to the public as well. There are some very limited circumstances in which you can have a meeting with less than 10 days' notice. If it is a special meeting or an emergency meeting. A special meeting is a meeting where there's a very limited purpose. It's called by the board chair or by a majority of the board. And it can only be called to consider pending litigation, proposed legislation, real property transactions when you're negotiating for real property, or the appointment of an interim chancellor. So it's very specific when you can have a special meeting. It requires 2/3 of the body to adopt at the meeting a specific finding that there was a need for this meeting, that it meets one of those criteria for things to be discussed, and that the information came to the attention of the board after the regular agenda was set, or there isn't enough time to do a special meeting, and that the immediate meeting is needed to protect the public interest. And so you actually have to have a vote at the beginning of the meeting that there's a need for a special meeting, even though it's already been noticed. And if 2/3 of the entire board don't vote to have a special meeting, or if you have less than 2/3 of the board, it isn't unanimous, and you call the meeting and you don't have it. An emergency meeting is even more limiting. It's when there is a crippling disaster or work stoppage. You give 1 hour's notice to the media. So if you have a work stoppage issue where we have an earthquake or something like that that requires immediate notice, then you can have an emergency meeting. But again, it's a very limited circumstance. In addition to special meetings or emergency meetings, you can add items to your agenda for your regular meeting if the topic would qualify for an emergency, if it's a crippling disaster or a work stoppage issue, or if the need for immediate action came to the attention of the board after the agenda was posted. Something happened during that 10-day period having to do with something that was for pending litigation, for example. A new case was filed. We could then amend the closed session agenda to discuss that case. You still have to give 48 hours notice to the media and post it on the internet as quickly as possible. Let's talk for a minute about closed session, because that's really the area where we have the most questions about the Bagley-Keene Act, and that is when you can talk and when you can't talk in closed session. The Act recognizes a very limited set of circumstances when you can talk in closed session, and it won't be surprising to you that they are in instances where the legislature has determined that for purposes of privacy or to protect the attorney-client privilege, frankly, those are the instances when you can talk in closed session. So the exceptions that are applicable to CSU, because there are a number of exceptions that are in Bagley-Keene, but only some of them are applicable to CSU, are up on the screen there. I'm not going to focus. I'll focus on the personnel, pending, and collective bargaining exceptions in just a minute. But some others just to be aware of: honorary degrees. We know the board can meet, the board's committee on honorary degrees can meet in closed session to talk about that, as can the board. advice regarding giving advice or authority to your real estate negotiator. Obviously, you don't want to be giving authority to your real estate negotiator in public session about what price you'd pay, and so they could be in closed session on that. And discussion of a criminal or terrorist threat to personnel or property at the CSU. You can meet in closed session on those items. The personnel exception is the one that we use quite frequently, as you know, to meet in closed session, and it's very clear. The board can meet in closed session to consider the appointment, employment, evaluation, or dismissal. Here it says of the CSU executive, and that's because most other instances of appointment, employment, and evaluation and dismissal of our rank and file employees or our employees in our collective bargaining units, they're covered by a process already. So that we're mostly talking about CSU executives. An important point here is that evaluation is very broadly determined. So it's not limited to that periodic formal evaluation. The Attorney General and the courts have said that you can meet in closed session to talk about the evaluation process for your senior executives, how often you're going to evaluate them, what criteria you're going to use, etc. And you can meet on a regular basis with your senior executives in closed session to provide them feedback, to get feedback from them on how they think they're doing, and to provide them feedback on how they're doing as part of the ongoing evaluative process. So it's not just every year or every 6 months that you can use that moniker, but you can meet in closed session under the evaluation moniker for more broad purposes. Beck, do you have a question?
That applies to the chancellor as well?
Absolutely, absolutely.
And why is it scheduled for open session then?
Well, we could talk about that. Let me just finish the presentation and we'll talk about that. As I said, it's okay to discuss the evaluation criteria and process in closed session if you'd like to. The pending litigation exception, oops, one too far. There are certain circumstances when you can meet in closed session as well to talk about pending litigation. That's when CSU is a party to existing litigation. That's the easiest one. We've been named in a lawsuit, an arbitration, or some other adversarial process. When CSU has, frankly, in the determination of your general counsel, substantial exposure to litigation, when I think there's an issue that you need to be aware of because we are potentially going to be exposed to a lawsuit, or when the board is deciding to initiate, whether or not to initiate litigation. Those are the instances when you can meet in closed session. Not surprisingly, your lawyer has to be present when you're meeting in closed session to talk about pending litigation, otherwise the exception doesn't apply. It's the full employment for lawyer provision of the Bagley-Keene Act. The collective bargaining exception actually is not even in the Bagley-Keene Act. It's in the Higher Education Act, in HERA. But the board is allowed to meet in closed session to strategize about collective bargaining and also to meet with their negotiator and provide direction and advice to their negotiator on how to move forward. So those are the collective bargaining exceptions. So the question arises, what's a meeting? We talked about the regular meetings, special meetings, emergency meetings, and we've talked about closed session and open session. Very clear that when there's a noticed meeting, these are the rules of the road that apply. But one of the tricky parts about the Bagley-Keene Act is there are instances in which Bagley-Keene would be applied where you wouldn't think you're in a meeting and you actually are. Under the Act, a meeting is essentially whenever a majority of the board, or if we're talking about a committee, a majority of any covered committee, a standing committee or an ad hoc committee that's covered by the Act, is participating in conversations about topics within the board's jurisdiction or that committee's jurisdiction. So when a majority of the board or a majority of a committee are having a conversation about something that is on the agenda, could come before the agenda, is foundational to making decisions in that committee or by the entire board about something that's within the jurisdiction of the board, then you're having a meeting. So that's how it gets tricky. So the circumstances that constitute a meeting are not always intuitive, as the slide says. It can be formal, noticed and scheduled, as I said. It can be informal and spontaneous, quite frankly, when a group of board trustees get together and start having a conversation. When there's a majority of the committee or the board present and they're having that conversation all at once, then that's a Bagley-Keene Act meeting, and of course, that means you should have had notice and an agenda, an opportunity for the public to be there to participate in and hear about what you're talking about. And even when there's less of a majority that's having that meeting, but it grows to be a majority through what's called a serial meeting, which we'll talk about. The first thing to know here is that briefings are covered here. As I mentioned earlier, one of the things Bagley-Keene wants to make sure of is that the public knows what information is being provided to you as a board that's going to be foundational to you making your decision. So merely receiving information can actually be a meeting. If there's a briefing before a meeting, whether by telephone or email or in person, where the majority of the trustees are there and staff is providing information to you that's foundational to something you're going to be looking at, whether it's a real estate transaction or anything else, then that's a meeting under the Bagley-Keene Act, and that the public has a right to be there and know what information is being provided. So the Attorney General is saying briefings on background information is part of the deliberative process, and has actually opined to say, if necessary, the best way to do that is to do it in writing and make that writing available to the public. I mentioned serial meetings. So this is not just when all or a majority of a committee or a board are meeting all at one time contemporaneously, but when the communications among the majority of the members of the board can happen over time. It's whenever there's a collective concurrence that's developed in order for the board to take action. So even though the members aren't all gathered together at the same place at the same time, it can constitute a meeting. It can be direct, it can be through personal intermediaries, or actually through the use of technology. So let's talk about each of those quickly. First thing to understand, this isn't only an issue if the conversations that we're talking about, the communications that we're talking about, are there to advance in providing clarity or helping in reaching agreement on substantive matters. So if all the communications are about is who's available for a meeting, or what's going to be put on the agenda, times or placements of items on the agenda, you're not going to violate the Bagley-Keene Act, even if a majority or more of the board, I'll chime in, I'm available on January 10th. The public doesn't need to be part of that, or we're going to add this to the agenda or that to the agenda. But if you're having a substantive conversation at all, then Bagley-Keene's going to apply. There are two types of serial meetings that the Bagley-Keene Act recognizes. One's a chain meeting, and the other is a hub of the wheel meeting. A chain meeting is just what it sounds like. So here's an example where Trustee A has a conversation or a discussion with Trustee B, and Trustee B then has that conversation with Trustee C, and so on and so on. And he told a friend, and they told a friend. And as long as you don't have a majority of the board, then you don't have a Bagley-Keene violation, or a majority of the committee if it's something to come before the committee. So if that serial meeting, that chain meeting stops short, then you don't have a Bagley-Keene violation. The problem is when Trustee A had that conversation with Trustee B, and then Trustee B had that conversation with Trustee C, you don't know how long that's going to go on. And the first two conversations may have been completely innocent with no intent to violate Bagley-Keene, but then all of a sudden 5 members of the committee or a majority of the board have had a conversation, and you've unintentionally violated Bagley-Keene because everybody's had that feedback. Another way in which this can occur is the hub of the wheel meeting that we were just talking about. A hub of the wheel meeting is where you do exactly the same thing, but it's through a person that facilitates that conversation. Quite often this could happen if a senior staff member or executive at the Chancellor's office starts having conversations with different trustees from a committee or even for a majority of the board. Once a majority of that committee has had conversations with that staff member, you've created a Bagley-Keene problem. A board chair could do this. It could be anybody. It could be a member of the public, as long as that information is shared and then gathered in order to create a consensus. So that's what a hub of the wheel meeting is. Importantly, with the advent of email and texting, this has become an even harder situation because what starts happening is those emails get forwarded, or you hit reply all to a conversation, and next thing you know, you have a majority of the members of a committee who've shared information, or a majority of the members of the board who've shared information. And this is not curable by simply posting and saying, by the way, we happen to have had a meeting, we inadvertently shared emails or texts, and so now we're telling everybody we did it, or even sharing, the Attorney General has said, sharing all those emails or sharing those texts and posting them on the internet. That still doesn't cure the problem. You violated the Bagley-Keene Act. So I want to make sure that the board is aware of that. It is important to know that there are a bunch of exceptions to the Bagley-Keene Act for trustees to get together. Social or ceremonial gatherings, when you go, of course, to graduation or to poster sessions or things like that, those are not the Bagley-Keene Act, as long as what doesn't happen is a majority of a committee or a majority of the board doesn't get together at that session and have a conversation about what's going to come before the committee or come before the board. That would violate the Bagley-Keene Act. Conferences or retreats that are open to the public generally and are of general information of interest to the public that board members attend. Maybe there's a national conference for for trusteeship on how to be a good trustee, for example. You wouldn't violate the Bagley-Keene Act if a majority of folks went there or majority members from the committee or a board. Unless, again, what happens is you all sat together at the dinner that night and started talking about board business, then you'd have a violation of the Bagley-Keene Act. And of course, individual contacts between board members that don't turn into a serial meeting, don't turn into a hub of the wheel meeting, and individual contacts with members of the public, with students, staff, faculty, etc. You can always have those conversations as long as a hub of the wheel meeting isn't created or a chain meeting isn't created. So if you just be aware and responsible that you're recognizing the fact that there's no prohibition against one trustee talking to another, and you're careful to avoid a majority, and careful to assure that you're not creating a serial meeting or a hub of the wheel meeting, then you haven't violated the Bagley-Keene Act. One way to alleviate that problem is if you have questions, if you address that to senior members of staff here at the Chancellor's office, we make sure that we don't violate the Bagley-Keene Act by creating conversations with a group of trustees from a committee or a majority, and then thereby creating a consensus. So we will keep track of that, and you won't have to. What are the ramifications if you violate the Bagley-Keene Act? Well, first of all, your board action could be overturned. So if you took action and you violated the Bagley-Keene Act, if it wasn't on the agenda and you took action on a matter, or you decided something collectively as board members for a committee or as a majority, that action is voidable if someone sues the board to do that. You can have injunctions against future activity. It's actually a crime. It's a misdemeanor to knowingly violate the Bagley-Keene Act. I will tell you that there have never been any prosecutions for the Bagley-Keene Act or the Brown Act or any of these other statutes. I certainly don't want us to be the first, but you have to knowingly have violated the act, and I don't think any of our trustees would intentionally do that. But it is really important that this is a public relations issue as well. I know the board is committed to following the statute and doing its business in public, so members of the public can actively participate and comment and know what's going on. And it's not a great thing for the public to make the determination that we have been engaged in communications away from the public and making decisions away from the public when we weren't supposed to. So suggestions for conversations outside of the public meetings, again, directing inquiries about board business to senior staff rather than fellow trustees, as I just talked about. We can help regulate whether there's been a violation of the Bagley-Keene Act. We can act as the gatekeeper. And unidirectional briefings or briefings from us, from staff when necessary, and we can control and make sure that the information is made available to the public so that the act hasn't been violated. There is your primer in, I don't know, 15 minutes or less, something like that. And I'm happy to answer questions, again, with the idea or concept that I'm happy to talk about what the Act requires generally. I prefer not to talk about specific scenarios because that's when I give you legal advice, and that should be as part of the attorney-client privilege. Beck?
So just so I'm sure, we can direct comments to the staff, but the staff can't then become the hub
Exactly.
of a set of conversations.
So when you're, for your committee chairs, for example, when you're having conversations with your respective vice chancellor or deputy vice chancellor, we charge ourselves with making sure that we're not violating the Bagley-Keene Act by getting information from all our different members of the committee to try and gauge whether there's a consensus or not. Because what we could inadvertently otherwise try to guide the communications and share with one committee member what another committee thought or make arguments on behalf of, and you've thereby circumvented the process.
So for board business, you don't want details, but I just asked Stephen something, some questions. That wouldn't be board business? I mean, asking him for information, so that's okay.
Two answers to that question. The first is, if we're just talking about process and rules and regulations, what do the board rules say about this? You haven't violated the Bagley-Keene Act because we're not talking about a substantive matter that's going to come before the board and you're going to make a decision on. The second thing is, two trustees can always talk to each other. Now, if what happened is, you said to Stephen, now, what do you think about the new academic program that they're rolling out to increase graduation rates?
Yeah.
And then Stephen said, well, I think it stinks. And Stephen turned to the next person and said, what do you think? And then that's when you create the problem. No, just in time.
So Fran,
What would be a way to happen if we're having a discussion, let's say, around a real estate or building matter on one of our campuses, and a question gets posed that all of a sudden ties into something that may be under privilege or proprietary. How does that get called in real life so we end up as a board not asking questions or doing things that are going to, people didn't know there was a lawsuit pending or things of that nature. There are different topics that can come up appropriately noticed in the public session that because of the set of circumstances that may have occurred overnight, all of a sudden get perfectly intended, well-intended questions on the wrong side. Can we immediately go into a closed session, and who calls that? Or do we call a timeout and have an attorney conversation with the chair?
If during the course of public session you're talking about an item that's on the agenda, that's properly noticed, and I'll use a perfect example. Let's say we're talking about a building program and there's an environmental impact issue, a CEQA compliance issue. If the board is talking about whether or not to approve the environmental impact report, staff is making a recommendation to you and providing information. To the extent the board is simply deciding, based upon the information, whether to approve or not approve the environmental impact report and move the project forward, that's fine. If all of a sudden the board starts having, or any member of the board starts having, thorny legal questions, first of all, I'll be there, and I would expect they would probably ask me, and even if they didn't, I'd probably raise my hand and I'd say, those are issues that are of a legal nature, and I'm happy to answer those questions, but in order to preserve the attorney-client privilege, we would have to do that in closed session. We cannot immediately adjourn closed session. That would have to be put on the agenda for the next meeting, and if it was too far away, you needed to do it sooner, we would call a special meeting to do that.
A question about price or something like that that's well-intended,
Sure.
all of a sudden gets to market, and loses the strategic advantage that the campus may have in acquiring something.
Right, and that's a great example, Tim. This can make the board much less nimble than it otherwise would be in conjunction with the negotiation process in particular. And that can be for a real estate transaction, for collective bargaining, or any other purpose. And which is why the board should have, and does have, fulsome conversations in closed session with their negotiator, and should be thinking a little bit more about strategy and where, what kind of authority their negotiator is going to need to have. So if you're talking about a real estate transaction, for example, you're not going to want to just give some authority to your negotiator. You're going to want to think about what is your end game, and where is it that the board would eventually go, and when should that negotiator stop and maybe say, I have to go back to the board, and when would the board be willing to come back for a special meeting on that issue? That's all part of the closed session discussion.
And if it was just a very short window to make a go, no-go decision, we could call a special meeting,
Right.
notice it in 48 hours, have that meeting by telephone in order to give them the authority and direction to a transaction.
In some instances, we
Yeah.
have to, there are certain gates we have to go through before that could happen.
Yeah, good. Okay.
Other questions, comments? Adam?
Thank you, Fran. A couple of quick questions. Just to be clear, you said serial meetings, the threshold is a majority of the board.
Right. Or the committee.
Understood. And yet, a committee, the threshold is 2 members.
Right.
Okay. And then,
Well, if the it depends on how many members the
if it's a
committee
standing
has.
committee,
Some of your standing committees have 8, some of your standing committees have less. It's a majority of the committee.
I thought that one slide said anything that's 2 members or more would be subject to.
Oh, that's to be subject to, you, absolutely, I misunderstood your question. If the committee has 3 members or more, then it is covered by the Bagley-Keene Act. If the conversation among the members is less than a majority, then it's not covered by the Bagley.
Second, you just mentioned telephone. What other provisions regarding telephonic participation, either in closed session or committees or board meetings?
Sure. The Bagley-Keene Act does provide for telephonic meetings. There's a requirement that at least one trustee be at the place where the meeting is noticed, here. And that a second requirement is that wherever the other trustees are on the other end of that line, it has to be both accessible to the public. So you're not going to do this in your car while you're driving along, for example. And the public has to be able to hear what's going on and have the opportunity to make comment. So you could do it in an office or a conference room or a hotel or something like that, where there's the ability for the public to hear everything that's going on and make comment.
I'm almost ready for my final exam on Bagley. But is it true to say then that no matter what the circumstances, national emergency, national emergency or whatever, the minimum amount of time for notice is 48 hours?
Yes, for an emergency meeting, exactly.
Okay.
So if we had to meet after a devastating earthquake or a national emergency, theoretically,
The soonest would be 48 hours.
but in practicality, we meet. And what we would do is we would do the business in public and we engage in as much substantial compliance as we can, so that we can still do the business of making sure our students are safe, making sure our buildings are safe, that sort of thing.
Thank you.
Fram, thank you for the thoughtful review. It's always helpful. If you've heard it once, it's good to hear it again and again and again, because all of us, I know, want to be sure we're conducting the public's business correctly. You mentioned earlier that there may be follow-up questions, and it can be asked directly to you. But, we had a little discussion earlier today about best practices, and one of the elements that I understand of best practices is that it's important that that everybody hear the same information, that even advice to one of us, it's important that everybody be able to take it, to have the advantage of that information and that insight. So accordingly, I wanted to ask that we have the opportunity to have a further discussion about this issue in closed session, so that questions that members might want to ask that they're sensitive to, given the counsel that you've provided to us, could be done where everybody would have the benefit of that thoughtful feedback that we all could hear at the same time. So as the schedule will allow, I don't know if our closed session agenda that we have for tomorrow would be appropriate for that, but I did want to make that request.
First of all, I'm thinking about Larry's question. I want to make sure I correctly. The special meeting requirement is a 48-hour requirement. The emergency meeting is an hour requirement. And so I apologize for that. I was thinking about the special meeting. So we would still be able to. On Steve's piece, just to have a general discussion, this is kind of instructive, right? Just to have a general discussion about how the board would operate and communicate under the Bagley-Keene Act, you have to do that in public session, which is why we're doing this in public session. So any discussion that we have about that sort of issue would need to be tethered to one of the exceptions, the personnel exception, the anticipated litigation exception, the real estate or collective bargaining exception. Otherwise, you just can't have that conversation in closed. It could be tied to evaluation. It could be tied to some process.
But if it's tied to your memo that you've written about under attorney-client privilege, it's a memo that's been prepared under attorney-client privilege. Is that an appropriate thing to agendize to discuss?
No.
Your memo?
No. Not the only way in which it would be I can write communications to the board under the attorney-client privilege, and I do, and you receive them, and they are protected. But that there is not the only time in which I can meet with you in closed session to discuss litigation matters or legal matters and provide you with legal advice if it meets one of the criteria under the Bagley-Keene Act, which would mean it would have to deal with personnel or litigation, anticipated litigation.
I'll leave it to you and the chair to figure out what's appropriate. No one wants to do anything that's inappropriate. Sure. But to ask a question about the appropriateness of the guidance that you provided under attorney-client privilege seems like it might fit into the appropriate category, but I'll leave it to you and the chair to figure out.
You can also always ask me you can ask me or as your counsel those questions individually, and I can share my answers with the board under the attorney-client privilege.
Well, then, I think that may be a successful way to advance that. I think that the underlying point that I was making is that we should all have the benefit of the advice that you're providing, and it's not the advice that you provide or any of our staff provide to us aren't really meant for one trustee. They're meant, the whole board should have the benefit of that information. Absolutely. Since we all act collectively on all these matters. So however appropriate, sure. I just think it'd be helpful.
So I may be not the brightest bulb in the room. So I think what just got asked and got answered was if our general counsel sends a memo to the trustees under privilege on some matter, and a trustee has a question about that, either doesn't understand something or challenges an assumption or whatever the query might be, that individual trustee can get back to general counsel with that query, and general counsel then can write a response to all of the trustees. I received a query from a trustee regarding blah, and we've done further work on case law about blah, and here is the outcome, right? So did I summarize it in sort of a flow? That would be privileged in every direction, right?
All correct.
Yeah. Right, and so the only follow-up to that is that within the discretion of the chair, that we would be able to have a conversation about that follow-up memo and that advice that's been offered within the confines of executive session.
Yeah, I think going back to Tom's earlier presentation, the advantage of having a competent team around us is to be able to get the best advice possible, and I think such that counsel is giving legal advice and on matter X, whatever X might be, and you should want clarification, and you as a board member want to make sure that everybody has the same data. Yeah, I would feel very comfortable with counsel making sure that everyone had that. I think part of that is just working through our process here to refine our communication. But I think we're all going to do a better job if we all have the same questions clarified, because as is typically the case in these matters, 5 of us may have had the question, but only one of us had the time to flag it, right? So I think it's a good discussion point.
But I think Trustee Glazer's question has one other piece, though, and that is, at the discretion of the chair, can it be then discussed in the subsequent closed session?
No.
And I guess that would then depend on what the topic is, right? If it's one of the exceptions, yes. If it's not one of the exceptions, then the answer would be no.
If it has to do with pending litigation or a personnel matter, etc.
The exception,
right?
Right.
Okay. Anyone else on the topic of Bagley-Keene?
Doesn't mean we couldn't discuss it. I want to stay on this point because it's an important one.
Yep.
Doesn't mean we couldn't discuss it. It just means we'd discuss it in open session.
Absolutely.
Mm-hmm.
The board can, even the things, there are there's the ability of the board to discuss many of the things that you would discuss in closed and open if they so choose as well.
Okay. Why don't we do this? Mindful we just came off of lunch. Why don't we take a quick 5-minute recess for anyone who wants some water, coffee, use the facilities, et cetera, and then we'll reconvene. We're going to go into board communications. Should we, for the purposes of that discussion, distribute kind of the roles and responsibilities document, or how do we want to proceed into that, Chancellor?
You bet.
I think that's a good place to start. Yeah. Okay. Get 5 minutes.
This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly. This is the California State University Office of the Chancellor's live stream. Please adjust your audio accordingly.